Hi, welcome to Module 4. In this module, we are going to discuss the Pollution Adjudication Board. Specifically, we have the following learning objectives. First, we determine the legal basis for the creation of the Pollution Adjudication Board. Second, we identify the powers of the Pollution Adjudication Board and the nature of said powers. Third, we delineate the jurisdiction of the Pollution Adjudication Board. And fourth, we illustrate the relevant rules of procedure applicable in the proceedings with the Pollution Adjudication Board. Let's start with the first learning objective, which is on the legal basis for the creation of the Pollution Adjudication Board. And it's best discussed with a timeline starting in 1964. Because in 1964, the National Water and Air Pollution Control Commission, or the NWAPCC, was created. Okay? And it was created by virtue of Republic Act number 3931, and by virtue of which, this is the charter of the NWAPCC, by virtue of which this office was vested with the power to determine if pollution exists in any of the waters and or atmospheric air in the Philippines. Then in 1976, the NWAPCC was renamed to National Pollution Control Commission, or now in short NPCC, which was vested with the power now to not only determine the existence of pollution but also to determine the location, magnitude, extent, severity, causes, effects, and other pertinent information regarding pollution of water, air, and land resources in the country, thereby expanding the initial power that was given by virtue of RA 3931 in 1964. All right. However, uh, in in consonance with the governmental overhaul and reorganization that happened in 1987, the NWAPCC was abolished, and by virtue of Executive Order number 192, the Pollution Adjudication Board, or the PAB, was created. What it did additionally is the powers and functions of the former NWAPCC and NPCC were transferred to the Pollution Adjudication Board. And so the creation, the existence of the Pollution Adjudication Board can be traced to the enactment, promulgation of the Executive Order number 192 in 1987. All right. Now let's go to the second uh, learning objective, which is on the identification of the powers and functions of the Pollution Adjudication Board. All right. Now the Pollution Adjudication Board, because it was granted with the powers that were previously granted to the NWPCC and NPCC, no? These powers are in the form of quasi judicial powers. Okay, to determine the existence of pollution and all such aspects of pollution. No, these are this is the power, no, that was granted or that was vested on the Pollution Adjudication Board. But aside from quasi-judicial powers, there are additional powers granted to it, like making, altering, or modifying orders requiring the discontinuance of pollution, specifying the conditions and the time within which such discontinuance must be accomplished. Um, Originally, the Pollution Adjudication Board was vested with permitting powers, except, however, when subsequent laws or other laws provide for other government agencies, uh, which will have the power, no, the permitting powers, okay, over specific uh, matters or subject matters. Also, the Pollution Adjudication Board is granted with the power of arbitration, okay, as we shall discuss later on, and such other incidental and necessary powers, including the issuance of writs of execution, of course, unless otherwise provided by law. But the main uh, characteristic or the main power of the Pollution Adjudication Board is quasi-judicial. It's an adjudicative body, hence it has quasi-judicial powers. Okay? But now, speaking of quasi-judicial powers, we naturally would lead to the discussion on jurisdiction. All right? Because when you speak about quasi-judicial powers or the exercise of quasi-judicial powers, you're also speaking about a grant of power, a grant of authority that is, in this case, limited in nature. All right? And that is bounded in nature. And so, this authority or jurisdiction to exercise quasi-judicial power must be studied insofar as the limitation of the law, as the scope, insofar as the scope and limitation of the law. All right, and so the exercise of these powers must then be limited by what is provided for by law, and such limitation is found in the jurisdiction of the Pollution Adjudication Board. And now, when we're talking about jurisdiction of the Pollution Adjudication Board, we now go to cases which illustrate, all right, um, scenarios where the court held that the Pollution Adjudication Board has no jurisdiction, and in some cases the court held that in this case it's the Pollution Adjudication Board which has jurisdiction. And for me, the great way to open this discussion on jurisdiction is the case on a case of AC Enterprises Incorporated versus Frabel Properties Corporation, now decided in 2006. And the background of the case can be summarized by this picture. All right, wherein here you see a building, no, called the Felisa building, owned by AC Enterprises, and we have the Frabella One, no, owned developed by Frabel uh, Properties. All right. Now the controversy here revolves around the operation of Felisa building. All right. Of its the operation of its 36 blowers. All right. These blowers are the exhaust mechanism of the air conditioning system in the Felisa building. Now, the problem here is that uh, these blowers produce so much heat, and these blowers also, according to Frabel, these blowers cause so much noise to the point that these become a nuisance. All right, and so Frabel tried to get reliefs from so many several government agencies from the excessive noise, according to them, that's produced by the blowers. All right, so they went to the DNR EMB, to ask for a study wherein the DNR EMB said the noise is excessive insofar as this area is concerned. But then there's a finding that not only was the noise created by the blowers, It's also apparent that the noise is caused by, is also the cars passing by this road also contribute to the noise here. Okay, so they went there, EMB, but then there's no relief asked there. There's just a request for a study or technical study on the matter. Insofar as government agencies which were asked for relief here, Frabel went to the local government unit. Okay, it also went to the Pollution Adjudication Board, and it went to the Regional Trial Court. Okay, as summarized, here we have the forums involved: the Pollution Adjudication Board, the local government of Makati, and the Regional Trial Court. Okay, now in the Pollution Adjudication Board, the Frabel here were alleging that there's pollution, okay, coming out of the blowers, and so the Pollution Adjudication Board should take action on this matter. Okay, but for the local government unit of Makati and Regional Trial Court, Supreme Court, the Frabel uh, properties here allege that there's nuisance, and so they wanted the local government unit of Makati to abate the nuisance, abate the operation of the blowers, and they also asked the regional trial court for the abatement of nuisance. Now, we have these three forums involved, but only one of them was considered by the Supreme Court to have jurisdiction to take cognizance of this controversy. Okay? And so the Supreme Court tried to eliminate those forums which do not have any jurisdiction on the matter. Okay, so the Supreme Court said in trying to answer this question of which forum has proper jurisdiction, the Supreme Court said the Pollution Adjudication Board has no jurisdiction. Okay, it has no jurisdiction. It has no primary jurisdiction over the noise complained of by the respondent. All right. Um, this this no this complaint does not require any special technical knowledge or expertise and experience of the pub. And in fact, the Pollution Adjudication Board declared that it was not a pollution case. Okay, but then why? After hearing these justifications, why is it that the Pollution Adjudication Board has no primary jurisdiction? Why is it that the Pollution Adjudication Board, why is it that the controversy does not require any special technical knowledge or expertise or experience of the pub? Okay? According to the Supreme Court here, it appealed to it resorted or it consulted the charter of the former NAAPCC, which powers contained therein, diba, were transferred to the Pollution Adjudication Board. It says there that pollution means any alteration of the physical, chemical, and biological properties of any water, air, or land resources of the Philippines, or any discharge thereto of any liquid, gaseous, or solid wastes, and such discharge will have detrimental, harmful, or injurious effect to public health, safety, welfare, etc., etc. Okay? And so according to the Supreme Court, in order to determine whether a case falls under the jurisdiction of the Pollution Adjudication Board, we have to determine first whether this case is a pollution case. All right? And how to determine whether the case is a pollution case? First, let's look at the allegations, the material allegations of the complaint, because it's the material allegations of the complaint which will determine whether the complaint involves a subject matter that can be considered as pollution. Here, in this case, according to the Supreme Court, it does not involve pollution. It does not involve pollution because it's a matter of noise. The complaint is about noise, and noise does not amount to any alteration of the essential properties or characteristics of any resource. It does not also amount to any discharge into the resources, which discharge will have detrimental, harmful effects to these resources, injurious to the utilization of these resources. And so, according to the Supreme Court here, this is not a pollution case. And because this is not a pollution case, this does not fall under the jurisdiction of the Pollution Adjudication Board, because the Pollution Adjudication Board only has primary jurisdiction over pollution cases. All right? Now, just to proceed with the discussion here by the court, the Supreme Court as well said that the local government unit here of Makati does not have any power to abate this nuisance. While the Supreme Court agrees that by virtue of the local government code, the Sanggunian is empowered to enact ordinances that declare, prevent, or abate noise and other forms of nuisance, the court said here that the Sanggunian Bayan cannot declare a particular thing as a nuisance per se and order its condemnation. Okay? Because this action requires an exercise of judicial powers. Sanggunian Bayan, being not a court, cannot exercise judicial powers. It does not have the power to find as a fact that a particular thing, especially if it's a private thing, a private nuisance, no, and it's not a nuisance per se, no, it cannot authorize the extrajudicial condemnation and destruction of that nuisance, which in its nature, situation, or use is not a nuisance. Okay, those things, again, because this requires exercise of judicial power, those things must be determined and resolved in the ordinary courts of law. Alright? And if that thing be in fact considered as nuisance by the competent courts of law, then the Sanggunian Bayan, then the Sanggunian Bayan will have now the power or authority na by virtue of that judicial determination. But without such judicial determination, right, then Sanggunian cannot have any power or jurisdiction to order the abatement of nuisance here. Okay? And so, the Supreme Court said it's the RTC which has the jurisdiction here. Because this is a case primarily for abatement of nuisance, then this case must fall under the jurisdiction of the regular courts. Okay, this is for the judicial abatement of private nuisance, and so this must be determined whether the blowers are indeed a nuisance or not, must be determined by the ordinary courts of law. The problem, however, is that there are so many ordinary courts of law. Now, which of these ordinary courts of law will have jurisdiction, right? And so the Supreme Court here discussed that this case involves judicial abatement of nuisance, and that action for judicial abatement of nuisance is not one which can be estimated with value. It's not one that has value, a fixed value or amount coupled with it. In fact, according to the court, this action is an action that is incapable of pecuniary estimation. And because this is an action that's incapable of pecuniary estimation, under the Judiciary Reorganization Act or the Batas Pambansa Bilang 129, such action must fall within the exclusive jurisdiction of the regional trial court. Okay? And so according to the Supreme Court here, it's the regional trial court which has jurisdiction, not the local government unit, and more importantly, not the pollution adjudication board, because this case is not a pollution case. All right. Now, uh, that's a case which now the case of AC Enterprises versus Frabel teaches us that the jurisdiction of the pollution adjudication board is limited. Okay, it's limited insofar as the the tribunal only has jurisdiction over pollution cases. And pollution cases are those cases which involve facts or material allegations that amount to pollution as defined in the charter, okay, in the presidential decree number 984. All right, and so now we go to the kinds of jurisdiction, uh, which involves as what we discussed, no, the general jurisdiction of the pollution adjudication board. Okay, the general jurisdiction, that is the jurisdiction of the pollution adjudication board over all pollution cases except insofar as provided by special laws. Okay, and this general jurisdiction uses the general definition of pollution in the charter, in the pollution adjudication, in the presidential decree number 984. Okay, which refers to any alteration of the physical, chemical, biological properties of any resource, discharge thereto, which will have adverse consequences, etc. etc. Okay? Now that pertains to the general pollution. And if a case falls under these items that constitute pollution, then that case or controversy will fall within the jurisdiction of the pollution adjudication board, such as in the case of Shell Philippines Exploration versus Halos, decided in 2010. Okay, which involves here the construction of drilling structures, no, meant to extract oil from below the seabed. Okay, and the such operation requires of course the transport of any extracted oil through pipes like these. All right, pipelines, underwater pipelines, wherein extracted fossil fuel are pumped in and out of the extraction zone, and then it goes to refinery and such other processes involved in the production of the consumer ready gas and oil. All right. Now here, because this is underwater, because the operation of the pipeline is underwater, there is a complaint that the continued operation of these pipelines contributed to the disturbance in the marine ecosystem here, no, in underwater where the pipelines are being operated, such that fishermen like Halos and company were experiencing significant decline in their catch, in their yield, right? And of course, because these are subsistence farmers, they rely on their everyday catch, everyday yield. They their income is directly proportional with their yield, with their catch. And so when their yield or catch is significantly affected, it significantly decreased, their income as well was significantly decreased. Okay, and so they filed a case for damages against Shell Exploration. All right, stating that they lost income, they lost catch because of the continued operation of the pipelines. they wanted Shell to give reparations to their lost income, to their lost catch. So they filed it. They filed the case for damages with the regional trial court. All right, they filed it with the regional trial court. Now, the question here is whether the regional trial court has jurisdiction over the complaint. Remember, it's a case, it's a complaint for damages, presumably more than 300,000 in sum, all right? And so the regional trial court was the court, no, where it was filed, all right? But then Shell Philippines here questioned the jurisdiction of the regional trial court. Okay, in fact, they moved for the dismissal of this case because, according to them, jurisdiction pertained to some other tribunal. Now, in answering this question, no, does the regional trial court have jurisdiction over the complaint? The Supreme Court had to examine the material allegations in the complaint. And the Supreme Court said here that yes, this case or the complaint does not invoke the term pollution. It does not use the term pollution in describing the cause of the alleged fish decline in the sea, in the Mindoro Sea. All right. However, notwithstanding the absence of the word pollution, okay, according to the Supreme Court, it alleged that the pipeline greatly affected biogenically hard-structured communities such as coral reefs, and this led to stress to the marine life in the Mindoro Sea, coupled with the allegations that there are leaks in the operation of the pipeline. According to the Supreme Court, the material allegations in this complaint constitutes pollution as defined by law. It constitutes alteration of the water resource, or it may constitute discharge into the water resource which injured the utilization of the marine resources there. And so, according to the Supreme Court, the material allegations in the complaint here show that pollution is the main cause of action here. No, this constitutes pollution as defined by law, and so according to the Supreme Court, because the material allegations here constitute pollution, then the jurisdiction should not have pertained first to the regional trial court. No, the determination of whether there is pollution or not must have been passed upon first by the Pollution Adjudication Board, okay, which has primary jurisdiction over this case, because according to the Supreme Court, Halos et al. Had an administrative recourse before they file the case or the complaint with the regular courts. The laws creating the PAB and vesting it with the powers are wise, according to the Supreme Court. This term pollution connotes the need for specialized knowledge and skills, technical and scientific, in determining the presence, the cause, and the effects of pollution. According to the court, therefore, resort should have been made first with the Pollution Adjudication Board, which is the agency possessed of expertise in determining pollution-related matters. Alright? And so, according to the Supreme Court, dismiss the case RTC because the primary jurisdiction pertains not with you, but with the Pollution Adjudication Board, owing to the fact that this case is a pollution case. But why dismiss? Why dismiss the case? We'll have to dismiss the case because of this All right, here, because of this effect of the specialized jurisdiction of the Pollution Adjudication Board. Okay, wherein this requires the specialized knowledge and skills of this administrative body. Okay, and such specialized jurisdiction is coupled with the doctrine of exhaustion of administrative remedies. Okay, where when administrative remedies are available, as a general rule, a party should seek the intervention of the administrative body first before going to court. Okay, the party seeking the intervention of the court should first exhaust all the available administrative remedies or processes. Okay, uh, otherwise, if there's no exhaustion of administrative remedies, then the cause of action, okay, with the courts would be premature. Okay, and because the cause of action is premature, or the invocation of the intervention of the court is premature, then the case would be dismissed on the basis that this case or complaint lacks cause of action. And here we have the rationale for the uh, doctrine of exhaustion of administrative remedies, no, both practical and legal, no. Practical, because you have administrative bodies which can provide administrative remedies. Let them give give them the opportunity to remedy, to give reliefs which are more speedy and more and less expensive insofar as the reliefs are concerned. But then again, legally, courts will also shy away from the dispute until the dispute has been subjected to the administrative redresses available for reasons of comity and convenience. It's so as to give the administrative agencies the opportunity to correct whatever error it may have committed and dispose the case. Note, however, that the this doctrine of exhaustion of administrative remedies is subject to several exceptions, which we will not belabor enumerating in this discussion. All right? Okay. Now, just to go back here to the matter of specific jurisdiction, also, while general jurisdiction in the term of pollution as defined under PD 984 is the basis for the general jurisdiction of the Pollution Adjudication Board, subsequent laws as well vest jurisdiction over cases, okay, which specifically define pollution, right? Such as the Clean Air Act, okay, for exceedance of air quality standards or limitations. Clean Water Act for exceedance of DNR effluent standards, for example, or Toxic Substances and Hazardous Wastes Act, such as illegal transport, dumping, or discharge of prohibited chemicals, etc., etc. These are specific jurisdictions because these are specifically provided by law, by subsequent laws, and while they may not refer solely to the pollution, to the term pollution as defined under the charter under PD 984, they nonetheless form part of the jurisdiction of the Pollution Adjudication Board because these are additionally vested specifically by law, right? Okay. And the last component of the jurisdiction of the Pollution Adjudication Board is arbitration. Now, arbitration, insofar as the Pollution Adjudication Board is concerned, we must note that arbitration is voluntary in nature here. No? It must be a voluntary arbitration, which means that both parties must consent to the exercise of arbitration jurisdiction of the Pollution Adjudication Board. If the other party does not consent, then voluntary arbitration cannot validly be had. Alright? Now, arbitration here, again, is voluntary. Note that not all controversies involving pollution can be under the voluntary arbitration jurisdiction of the Pollution Adjudication Board. Right? Section 1 of its rules provide that any claim for reparation or restitution of damages and losses that result from pollution of resources may be brought before the board of the regional office for voluntary arbitration. Okay? In short, we have three requisites in order for the Pollution Adjudication Board to validly exercise its arbitration jurisdiction. Number one, we have that the claim is for reparation or restitution of damages or losses. And number two, that damages or the damage or losses result from pollution. And number three, because this one involves voluntary arbitration, the parties consent to the arbitration. All right. Without these three requisites, the Pollution Adjudication Board may not validly exercise jurisdiction or arbitration jurisdiction. Okay. Now, the consequences here, if there is pollution and damage and it's proven as a result, pecuniary liabilities will arise. Moreover, if the pollution results in the death of fish or other aquatic life or destruction of natural habitat, the person responsible for the pollution shall pay the government for damages, not just the aggrieved party here, but also the government for damages for fish or aquatic life destroyed. No? The reasonable value will be ascertained in consultation with the expert agency on these kinds of matters, in this case, Bureau of Fisheries and Other Aquatic Resources, or BFAR. Okay? Just note that when there is an assumption or there's an exercise of the arbitration powers of the Pollution Adjudication Board, pecuniary liabilities will arise, meaning damages may be awarded by the Pollution Adjudication Board in exercise of this arbitration jurisdiction, provided that the requisites are present. Okay? Now, in the next video, we'll have a discussion on the applicable rules of procedure for the Pollution Adjudication Board. Alright? And so, we'll have this discussion on the outline, on the flow of procedure insofar as relevant subject matters in these rules of procedure are concerned. Thank you for viewing this video and see you in the next part of our video.